Afternoon, and welcome to this session of the ABA Young Lawyers Division Spring Conference. This session is called Courtroom, Client, and Career, Effective Writing Tips for All Young Lawyers. My name is Ben Woodring. I'm an attorney at Mulla Lampkin. I'm incoming chair of the ABA YLD Litigation Committee, and I'm joined with my co-moderator.
Hi, I'm Aris Hanchard Ferguson. I'm general counsel for the Housing Authority of the City of Charleston in South Carolina. I'm an outgoing YLD scholar and incoming liaison for the Affordable Housing and Community Development Law Forum Committee.
And we have a great program in store for you today, focused on 3 different dimensions of writing: formal assignments, more informal communications, and writing about yourself. And our trusty guide today is Professor Lavanya Sabin. Lavanya is the director of the Bar Review Program Strategy in charge of MEE and MPT content development at AccessLex, a legal educational nonprofit. She's currently developing essay materials and writing strategies for Helix, a new cost-effective, innovative AccessLex bar prep program scheduled for rollout next year. She also provides private bar exam tutoring. She's a graduate of Georgetown and American University Law School. After graduating from law school, she practiced corporate law and then started her 17-year career in legal education as senior academic counselor at Washington College of Law. She realized the struggles students faced in passing the exam and began teaching bar essay writing, eventually prepping students for 2 exams in over 24 states. After moving to Charleston, she became director of bar prep at the Charleston School of Law. She's also taught bar prep at numerous law schools around the country, including University of South Carolina, University of Denver, Stern School of Law. She also provided content development services and was a professor lecturer for Kaplan, PMBR. And she is now an expert in all aspects of bar exam, but her specialty really is writing, and that remains her passion. So speaking to everyone joining us today, thank you again. You are welcome to submit questions throughout. And while we may address an occasional question mid-session, there is a designated Q&A at the end of this program for the final 15 minutes, where we'll put your questions to her, or as many as we can. The program is being recorded, and all attendees, both of this session and of the conference more generally, will receive an email after this session with a link to the recorded program, and to all programs from the conference. We will post the slides. You also get a link to the Litigation Connect page, and we will be posting the slides to the event page itself. And please stay tuned for any potential further follow-up based on questions generated, which Aris will also address at the end. So with that, I'm going to turn it over to our speaker, Professor Lavanya Sabin. Thank you.
Thank you, Ben and Aris. I appreciate the introduction. It's a real pleasure to be with all of you today. I hear that it's a big group. We're going to be talking, of course, about writing in all different aspects, legal writing. And basically, besides what we speak, written communication is the foundation of the law profession, the ability to communicate in written form. And it's so important because really, people don't know what you're thinking about. And so it has to be clearly articulated in the written material. You also may never get a chance to go back and explain what you meant. So it needs to be clear and concise. Today, we're going to go over just some general tips for writing. Then we're going to talk about more formal types of writing. That includes memos, briefs, drafts, client letters, informal communication, and career communication. So we have a lot to cover. This is the basics. We're going to try to go broad and cover as much as we can. And some of this are things that you probably have already learned in law school. Just going to brush off the cobwebs and see how we can apply some of those things to the actual work world. General writing tips. So any type of writing that you're doing, we're talking about writing clearly and concisely. Just remember, simplicity is really more impactful. You know, we're taught in law school to write maybe long sentences, lots of conjunctions, and make it as lawyerly as we can. But really, what we're talking about, it's better to go with shorter sentences. So if you have a really long sentence, and it's not making sense to you, take out the contraction, put down a period. Better it be choppy than it be too long. Don't cram a sentence with too many ideas, and longer is not necessarily better. Try to minimize errors. Errors will happen. Make sure that you have someone check your work if you can. Try to avoid words that don't really add anything to the writing, like we note. Try to avoid colloquialisms and jargon. And you're not really going to be using citations in Latin, Latin almost never, unless the document calls for it, or you have to use a very specific legal term. So be careful with those things. All right, formal documents. This is what we're talking about: memos, briefs and demand letters, drafts, and just general letters like client letters. The main things to remember is you have to know your audience. So find that out right at the beginning. Make sure from the directions or the supervisor who has assigned it to you, make sure that you know who you're talking to. Know what the purpose of your writing is. Are you trying to be informative? Are you trying to be persuasive? Make sure that you know. Follow directions. I cannot tell you how important following directions are. Your supervisor, whoever gave you the task, did not write about a bunch of directions for you to just ignore them. So it's very, very important that you follow them. Use rules to create organization. We'll talk about that in a little more detail. And make sure that you are talk about one thing at a time using headings and bullets. And again, we're going to go over some of these with some examples. Okay, your audience. Just remember, when you're drafting, you're not drafting just to make yourself sound good or sound good to yourself. You're writing for the recipient. So make sure that you know who that is. And also, you have to know who it is to write effectively. I think the biggest thing to remember, especially when you get into practice, is that different types of clients have different types of knowledge, skill sets, and sophistication. It's important to keep that in mind. So with your memo, you know it's objective. Remember this from first year of law school. And it's supposed to be an honest evaluation of the case, its strengths and its weaknesses. It's internal, and it has to have verifiable information that really that would inform the client, but most of the time it's informing your supervisor, kind of where the case stands. Right. So for briefs and demand letters, it's supposed to be persuasive. It's usually an external document for public consumption. And you can acknowledge the weaknesses, but you can't just say, here's our weakness, and then just move on. You have to sort of reconcile it with what you're trying to do. I have had people who actually just say, like thinking it's a memo, saying that, you know, well, our client lost on this point, and then there's nothing else. So that's not a good plan. You're going to have to sort of balance it out with, it's not good for our client, but, okay. Drafts. Now, this is not something that typically people do in law school unless you're a part of a clinic. It's informational, it's external. This is like drafting, if someone asks you to draft parts of a will or draft parts of a contract. Okay, I was a contracts attorney, so I drafted parts or all contracts all the time. And I definitely was something I learned, I feel I learned on the job. The biggest thing I can offer you is that you really have to pay attention to what your client's objectives are. Sometimes you're going to include things in that document that are just for your client's benefit, and it's not really because there's some legal rule behind it. But you do need to pay attention to that. Client letters, again, not something I dealt with until I started out in practice. It is informative, it's external, and definitely the sophistication of the client is going to determine sort of how much you say the tone of the letter itself. And a sophisticated client might need something that is a little bit more complex about the law, but not necessarily a huge explanation about their business or the field. They may already know that. A less sophisticated client, you might want to not have as much about the law, but make sure that you are very clearly relating the law to their particular facts so they understand exactly where they stand.
So just an example of a sophisticated client letter example. The main difference between promissory estoppel and equitable estoppel, as outlined above, is that the plaintiff relies on the defendant's promises, not their actions or facts as offered. The controlling case is, this case defines promissory estoppel as centering on a promise made by a defendant under circumstances where considerations of fairness and equity will relieve the promisee from any adverse effects of his or her reliance on the promise. Here are the facts in your case.
And here is an example to a less sophisticated client. Another strong argument we have is that Mr. Smith made a promise to you. You relied on that promise by taking time off from work and buying new clothes. It was not fair to you when Mr. Smith did not follow through on his promise because you lost money. In this case, unlike our first argument, we only need to show that Mr. Smith made a promise. No action by him is needed.
You can see both of these things, both of these examples are explaining basically the same rule, promissory estoppel, but they're just phrased in a very different way, using the techniques I discussed. Okay. Let's talk about directions. Again, read directions carefully. I can't tell you how many times, at least I've assigned something and someone has come back with something, a format that was completely different, something they learned in law school and not something that I told them to do. Supervisors don't like that. That doesn't go over very well. Make sure you clarify directions if you do not understand. Don't be intimidated. It's better to ask about it before you write the whole direct document incorrectly. Just go ahead and ask. Just be aware there might be two sets of directions. You could have the task you're supposed to accomplish, but you might have something internally in your firm that says, we write memos this way, we write briefs this way, we write client letters this way. I think, Aris, you had an example in your job where, wasn't it board of directors meetings had to be written a certain way?
Yes, so we have monthly board of directors meetings, being a housing authority, and part of that requires us submitting internal reports from the different departments. So when I first started, there was kind of a memo format that they had that, you know, I had to compose, kind of outline my information to for the board of directors. So they gave me that template and I worked, you know, within that template to be able to provide my information.
So in every aspect, whether it's a firm or it's in-house, there are those types of documents. Okay. I will tell you, sometimes it's just better to go ahead and write the substantive things you want to say and then come back and format. Because if you don't, you can get very overwhelmed by trying to do it all at the same time. Get your thoughts down, get the law down, get your organization down, then come back and use the format that you're supposed to do. Okay. If you have very complex directions, as I had given you an example here, go ahead and break them down into smaller parts.
So if you look at here, you can see in the example 1, please prepare our brief in support of the motion to transfer the case. 2, be sure to follow the firm's guidelines on persuasive briefs. But 3, do not include separate statements of facts. 4, make all the arguments needed to establish that the state court should transfer the case. 5, anticipate and respond to any arguments against the transfer opposing counsel is likely to raise.
So you get that first set of directions, your head feels like it's going to blow up. You're like, oh my gosh, I'm supposed to do all of these things at once. Better to go ahead and break them down into smaller pieces and make a decision on which ones you have to handle first. Okay. Formal documents, I think one of the hardest things, I'm talking to Ben and Aris, one of the hardest things is to get started. So I'm going to give you some preliminary steps here. So draft a preliminary basic outline, acknowledge the directions, provide a quick summary of the conclusions, provide the reader a roadmap, create a defined structure, use IRAC, yes, you're going to still use IRAC, and finish with a call to action. Preliminary outline, you can use the directions that you got, or maybe they gave you a little background on the case, to go ahead and create just a bare bones outline. Just remember, sometimes the document, when they tell you about the case, they might refer you to another document. And you can use that to go ahead and create your preliminary outline.
So the example prompt here is, please prepare a bench memorandum addressing the issues presented by defendant's motion.
Okay. Then you go to the motion and you see there's two pieces of evidence, and then you break it down in response to that. You can see on the right-hand side, it says statement 1, and in this case, the motions were that it has to be excluded because it's hearsay and relevance, and then break it down again for statement 2. That kind of gives you an idea of where you're going. Acknowledge the directions. It doesn't have to be a long drawn out thing. Just acknowledge that you know what you're supposed to be doing. This indicates to the supervisor, well, hey, I paid attention to what you told me to do. It just also maybe gives that warm and fuzzy feeling to your client that you're actually going to talk about what they want to do. And believe it or not, people forget what they told you to do. And so sometimes you just have to remind them, this is what you told me to do, and so I'm going to do it now.
So just some examples of acknowledging ways that you can acknowledge the directions. You could say, as I understand it, your goals in this matter are, or you have asked us to advise you on, Mr. Smith, as you requested, I have reviewed the employment contract, you gave me or you have asked me to. Just any of those are examples to acknowledge the directions. Sometimes even in acknowledging the directions, there are going to be situations where if there's multi-parts to a rule, but some of those parts don't necessarily need to be discussed or addressed, or have been told to you that they don't need to be discussed or addressed, that's another area where you want to acknowledge the directions. And you may write out the rule and say the rule consists of, part A, B, and C. However, part C is not at issue here, and we will further discuss parts A and B.
Right. That does happen. That does also happen a lot. Thanks for that. That's a good point. Okay. Have a preliminary conclusion. Basically provide a quick conclusion to the outstanding issues that you've outlined. This really helps the reader kind of know where you're going to land up. And just assume, most supervisors are super busy, and just assume your client's always busy. So if they just pick up the first page, they can kind of get a quick read of what you're planning to do and kind of where it's going. And then later on, they can read the rest of your fantastic writing.
Just to jump in on that, I will say that that was something that I had to learn in this position. Our CEO, he obviously gets information and reports or whatever from different sources. And so sometimes I found myself wanting to overly explain or was very wordy in some of the correspondence that I would write to him or some of the memos that I would give. And the reality is that there's just sometimes not the time to have something that dense in front of you. Sometimes you really need to be able to access the information quickly. So that really is important, recognizing that you want to communicate, at least on the surface, in a succinct way, what kind of that conclusion is in the event that they're not able to read through the entire, research or background that you also have.
That's a great point. And here the example is very short, sweet, and punchy. As you requested, included in this letter is an accounting of both compensatory and punitive damages. Both awards are likely.
Yep, exactly. Something that quick, not a whole lot of detail. I know working as in-house counsel, general counsel, same like Aris, my CEO did not have a lot of time to just find out what the bottom line is. Maybe he'd take time later on to read it. So it is extremely important.
And I know sometimes it might feel weird looking at that last example that Ben just read, having something that may seem that short or that curt. But, you know, Lavanya can speak to sometimes that's really what's necessary for the circumstance. You know, as she briefly mentioned earlier, sometimes those lengthy sentences or, you know, lengthy information is not what's necessary. So it can feel a little awkward to be that short at times, but at appropriate times, the situation calls for it.
Just remember, most of the time, go with simplicity if you can. That was one of our fundamental rules at the beginning. Right, now the next step is you want to provide a roadmap. Now, many of you who did moot court or other types of things like that, you always were told provide a roadmap. So what you need to provide them with sort of where you're going, what you're going to discuss. I will say that numbering and bulleting is very helpful. It just draws your eye to the main points. Be concise, don't ramble. This isn't the time to put everything in there. And again, don't provide too many facts. You can create a roadmap using issues that are presented to you. It depends on what kind of a case you have in front of you or the type of document you're creating and what rules you're dealing with. Issues that typically lend themselves, roadmaps that lend themselves to issues typically are topics like wills, where you have a lot of different people and you have a lot of different types of things that you're giving away.
So an example, I'm concerned about issues in the will relating to the disposition of the joint account, the diamond ring, and the shares in XYZ Corp. What are A and B's interest in them?
And your roadmap for this might look like, addressed below are A and B's interest in the estate, specifically 1, the joint bank account, 2, the diamond ring, and 3, the shares in XYZ Corp.
You can also use, you can also create a roadmap from a multi-part rule. I love multi-part rules. If you can find them, put them together from your statutes and cases, this is very, very helpful. So what you do is you go ahead and state the multi-part rule right at the beginning, and I like to number or letter them. And then you bring down each element and discuss it in its own little subsection using a little IRAC format, or maybe all you're doing is the application and conclusion. So here's an example. Under the Indian Child Welfare Act, an Indian child means, and I've numbered these, 1, any unmarried person who's under the age of 18 and is either 2, a member of an Indian tribe, or 3, is eligible for membership in an Indian tribe and is the biological child of a member of an Indian tribe. So in putting this together, when I start to initially put my outline together, I use the rule. I bring down number 1 and I have age. So underneath that, I would probably have my application with regard to the age of my client and come to a conclusion about age. Then I would go to tribal member and provide my facts and my conclusion for that. At the end of going through these elements, I'd have sort of a big conclusion that would say whether this rule is applicable to my client or not. Okay. Make sure that you have a defined structure. It's very important in communicating your point. If people don't understand what you're saying, I guarantee you they'll go to someone else for the answers, and you really don't want that to happen. Again, use headings. It's very important to have visual organization when somebody looks down the page, as well as organization in what you're saying. Don't talk about too many ideas or rules or people at one time. You can go ahead and write your draft, what you want to say, but when you look at it again, make sure that it's not crammed with too many things. If it is, then break it up. Okay, we have this example of using a multiple issues, and then creating a from your roadmap to the outline. What do you guys want to read that out for me?
So addressed below are A and B's interest in the estate, specifically 1, the joint bank account, 2, the diamond ring, and 3, the shares of XYZ Corp.
Right. And so on the right-hand side, we've just basically broken that down, right? We've taken the joint bank account, the diamond ring, the shares, and XYZ. This is a perfect example of a wills type of question. You know, everybody wants everything. They want to account for all the different pieces of the estate. And so each person wants to know what they're getting. So in this case, it's just easier. I found it easier to divide it up by each piece of the estate, what was in it. Okay. Aha, we're going to still use IRAC, believe it or not. I think you guys know this, you're probably using it already. But I just wanted to reiterate that under each one of those subheadings, for the example I just provided, you would have a small IRAC. Break it down, don't have a big one. So A's interest in the diamond ring, tiny little IRAC. It might be a little bit different because you may not have this sort of typical issue statement where here the issue is. Your issue statement may just be substituted with a heading, okay?
We had a question kind of dealing with the roadmaps. So Taylor Kern asked, when you break out your roadmap / rule, would it be acceptable to put them into indented paragraphs as statutes would typically break down? So example 1, a person of 18 who is A, US citizen, and B, owns shares in the company. So would it benefit to segment those 3 out into different indented paragraphs?
So let me understand the question. So you'd have the bigger rule. Did she give you an example of the bigger rule? Is that right, Aris?
So it seems like he or she's basically asking that when you break out that roadmap and rule, would it be acceptable to put them into separate indented paragraphs? Or should they be, if it is a 3-part rule, should they be all together in 1 paragraph? Or can you space them out?
Yes, that is exactly what I'm recommending. We're recommending that you break them out into separate indented paragraphs. As long as it's not just like the age question I provided with the Indian Welfare Act, that was just a 1-line thing. The child was either 18 or not 18. But if it is more helpful for your reader to have each one of those things broken out, especially if you have a rule where you have to prove each of the elements to make that rule work. That way you can show that, that you've actually covered each one. Okay, hope that answers the question. Right, you need to have a call to action. What are you asking for? Most legal writing has a call to action. So based on what you've written, what do you want to happen next? Court to grant a motion, a client to decide we're going this way or that way, or the other side to say, hey, yeah, let's go ahead and get to the settlement table. It's important to know, to have something that you're asking for.
So here are some example call to actions. Given our recommendations, please advise us on how you would like to proceed. Or, we look forward to discussing settlement terms within the next 2 weeks. Please contact me with some possible dates for us to meet.
Perfect. I like the last one. That's my favorite one because you're sort of setting your time limits. You know, you're taking charge of the situation. If you want to get something done quickly, go ahead and give them some time limits. Okay. There's some final points about formal writing. If after you've created a document, if possible, set it aside for a few hours. It sounds good in your head when you first write it, but always when you look at it again, there's always things that, you know, don't make so much sense, or you clarify or clean up. I personally like to set my schedule so I have a day between writing it, the first draft, and then taking a look at it the second time. So if you have that luxury, then go ahead and do that. On the first review, take out anything that's just extra. Think about the sentence, think about whether you really need that or you've already said it, and get rid of it. Second, I like to check for just errors, just spelling errors, grammar errors, without worrying about the content and getting too wrapped up in that. And then third, again, make sure you followed the directions, that you have the correct format, and it's ready to be submitted.
And just to add on to that from those final tips, I had a personal example about the effects of writing something and then coming back to review it recently in response to the CARES Act and the eviction moratorium that was a part of that. There's been certain delineations that housing authorities certain requirements that housing authorities have to take in order to show the court that they are not subject to the CARES Act and the exclusions, the eviction exclusions that come with that. So I wrote a letter to the court recently where I was explaining why our housing authority wasn't, some of our properties were not subject to that act. And I had written the letter and actually printed it on letterhead, had my secretary put it on my desk for me to sign first thing in the morning. Then when I got back in the morning, I read over it and ended up changing half of it. I took out sentences that didn't need to be there. Some things that I thought I explained well, I actually didn't explain nearly half as well as I thought I did. So taking that time to kind of set it aside to be able to come back to it is very helpful, because I would have not wanted the judge to read my first draft.
Yeah, it's really critical. Sometimes you don't have that luxury, but if you do, or if you have a schedule, plan out the schedule so you can create time. I just wanted to add one more point, which I didn't kind of touch upon on the IRAC slide, and that is IRAC is not actually just for law firms or law practice. It comes in very handy in other types of writing as well. So if you go into an industry like consulting, government contracting, something like that, it actually, elements of it are very, very useful for proposals and other types of documents like that. So, you guys have a great skill set in that respect.
And just a quick question before we wrap up the formal correspondence portion. So say you've been asked to interpret a complicated statute and how it applies to your client's situation. So there are a lot of factors to consider, a lot of moving parts. Would you, for a memo, would you lay out all the facts first and then progress into each element of the statute, or would you break it up differently?
No, I definitely not put all the facts first. If you put all the facts first and then you have the full statute, you're asking the reader to match up the facts with the elements of the statute. You're just not laying it out as clearly as you should. And so they're just sort of like, playing a little game with it, and it makes it hard to read. So I recommend that you put the full statute at the beginning, not every single nuance, but the basics. That would be your roadmap. Then you break out each of the elements of the statute you're going to talk about and have your IRAC under that. So you'd have the general rule broken out, any additional nuances, and then your facts and your conclusion about that little element. I'll give you an example with like negligence, duty, breach, causation, damages. Bring down duty. Now, duty is not so self-explanatory. It just depends on the situation. So you would put your a more detailed rule at that point and then go on to your facts.
Thanks.
Great. All right, so let's talk about informal correspondence. Typical examples these days, of course, emails and texts. And the same rules apply: simplicity, conciseness, and a defined structure. Okay. I will say it is a bit challenging because it's hard to write concisely and with a structure in this type of writing, because it's very fast-paced. There's also a lot of room for errors, and it's easy to ramble. It's just quickly trying to get your point across. But always keep in mind that you still want to create sort of, here's why I'm calling you, I'm contacting you, this is what you need, this is what's going on, make a decision about this or that. Or I'm just here, I'm informing you, give me a call. If you have an important email, write a draft, set it in the drafts folder, set it aside, and just revisit it later. I don't know how many emails I have redrafted. Again, like Aris said with her experience, looked at it later and been like, do I really need to say all of that, or can I just get rid of some of this stuff? Okay.
Definitely.
In that case, don't add the email address so you don't inadvertently send it. I have also sent that follow-up email. Oops, sorry. This is what I really meant to send you. We all do it, but just try to be careful. Make sure that the subject line is clear and direct. And I think Ben has a good example for us.
Yeah, back in law school, I was a research assistant for a cherished professor, but one way that they would communicate sometimes is putting almost the entire body of their message into the subject line of the email. So you just have this interminable email title. So it was always a journey trying to decode those, but not necessarily the clearest way of communicating.
Yes, I've had really long subject lines also, and it just drives me crazy. Aris?
And on the other end of that, don't make your subject lines so simplistic to where they're vague and they're not, clear on what is being asked or who it's from. Because I know that our IT department sends test spam emails to employees just to test and make sure that they're following the security training that we go through. So sometimes you'll get those suspicious looking emails that have a weird subject line. So you don't want someone to think that your email is spam and delete it.
Yeah, I talk to a lot of students that I tutor, and they will send an initial email that says hello in the subject line. I'm like, oop, this is spam, definitely getting rid of this. So yes, that's good advice.
And now we have a question. So we were asked, is it okay to just put the case name in the subject line?
I would put some precursor to that. Like, why are you sending the case name? Is it like,
so if maybe it's
colon and the case name or something like that?
So maybe if it's an upcoming deposition or something like that, that you're asking a question about, you may put, Smith v. Smith, deposition on 6/19. Is that what you're saying?
Or just even like have the case name, and yeah, that's a good example. Or what you're asking for, additional information needed, or something like that. Why are you contacting the person about it? Use use a professional salutation. So no hey or yo. Hi or hello is appropriate.
Have you actually gotten yo in the past?
Yes, I have gotten yo in the past. That's why I'm using it as an example. I mean, you get it and you understand, because people are used to like sort of a more fast-paced communication these days with texts and something and things like that. And, occasionally there's a slip up, but I have received that. Include a salutation. Email is not text. You don't necessarily know, it's just appropriate in that situation. Also, be careful with your salutations. I know that we're much more informal. We have a much more business casual, I would say, environment than we've had maybe when I was younger. But you would still not address my parents as, hey, David, or yo, David, definitely not. You would say, Dr. David, or Dr. David Shashkant, or Dr. Shashkant. You just wouldn't do that with them. So just be a little bit careful. Okay. Keep your fonts classic. No need to get crazy. Do not use jargon or slang. Just don't know how that's going to come off. And if you use acronyms, make sure your audience understands them. The reason I'm saying that is my husband works in the defense contracting realm with cybersecurity. They have 101 acronyms. And sometimes he's just talking to me and he's just saying these things. And I'm like, I have no earthly idea what you just said to me. So don't assume. And I think you had a good example on fonts, did you, Ben?
Yeah, and we have a couple questions coming in, but
Yep.
real comment on fonts and craziness. You want your fonts to match, you know, the tone of your message. So a good example of not really accomplishing this was back in 2010 when LeBron James declared free agency. The owner of the Cavs at the time in 2010, Dan Gilbert, wrote an open letter to the city of Cleveland saying, we were betrayed and we're still going to win a championship anyway. And he was very angry, but he wrote the whole thing in a cartoonish Comic Sans font. So it just kind of undermined the gravity of this whole thing. So just remember to match fonts to the message you're trying to get across.
That's a good point. Just stick to the classics. I think that's the way to go.
So one question that we received was, is it safer to err on the side of formality?
I would say yes. It's easier for you to be more formal and then the person to come back with you like, no, please just call me so-and-so and say their name. So, you know, start with Professor Sabin or Miss Sabin, and then I can then give you the permission to say, no, please just call me Lavanya.
And another question we received was, what about thank you emails from training/virtual seminars hosted by law firms or just in general? Ultimately, they say they want to be marketable and professional. So is a thank you email after a training session common practice, or would it be annoying?
I think I don't know if there's an appropriate thing for that, but of course a thank you is always appreciated. As long as you keep it short, sweet, and, you know, to the point. I think it's fine. Again, with emails, you probably guys know a lot about these things, but talk about public things, not private issues. Be really careful about humor because people can't really read your body language. There's no body language with that email. So something that's funny or a joke you're making can come off really strangely, depending on the person. Include a signature block with your name, title, company, phone number. It's great publicity for yourself. Don't include a saying. I get lots of emails with the saying and I just sit around wondering, why did they put this saying on there? And also just make sure that you proofread. Okay. Watch your tone. Classic example is, don't put everything in all caps. People get that either like, oh, you're super excitable, or you're just shouting at them, one or the other. So just be careful about how you use, you know, uppercase or lowercase, underlining, bold. Cardinal rule, don't hit reply all unless you thought about it at least a few times. I've known people who've gotten fired for actually replying inappropriately with reply all.
And just real quick, for the most part, we're saving a bunch of the questions to the end, but this one has to do with this category. AJ asks, who exactly are these informal correspondence instructions relative to? Are we talking about internal to employees only or established clients?
Well, I think they're applicable across the board. Now, internally, I have conversations all the time with my co-workers that are going back and forth. So sometimes they're a little bit more informal. I usually do say the person's name and I close with just at least my name on there. We don't really treat it as text, but definitely it's a conversation that's going on. Obviously, if you're going to a client, if you're going to a senior partner or something like that, you want to be even a little bit more observant of some of these rules. Okay. Just remember, you know, nothing's really confidential in the digital age, so just be careful with what you're sending out there. You never know whose desk it's going to land up on.
Any young attorney that has done doc review knows that you don't want to put certain things in emails.
Right. Now about texts, that's becoming, I mean, more and more common to even talk to clients in that manner. Just keep them short. I am a big transgressor of this. I try to put all my thoughts in as this giant text. So I have to really work on that. Offer simple options, not a lot of explanations. Usually texts are going to be used after you have an established relationship. I wouldn't be using texts if you really have not cemented your relationship with the client. Once you sort of get the ball rolling, then this is fine to talk like this. Oh, here's one of the things. So don't send one-word text replies. People get offended, like my children, who apparently think I don't care about them because I just send okay back and forth. Just try to be. If you're talking to someone you talk to all the time, it's probably fine. But just be aware that people do get kind of upset. All right. Do we have any questions? Any more questions on that section?
I think we did, but I think we'll save them to the end just to make sure we get through the slides, and then we'll see that.
Okay. Career communication. We're talking about, I'm just primarily talking about resumes and social media. With your resumes, make sure there's no spelling errors or typos. I can't tell you how extremely important that is. The recruiter I talked to says she doesn't like to send it on to the hiring manager if there's too many errors in it. It just doesn't make her look good, that she's sending that type of candidate who doesn't seem to care too much. Use past or present tense, but don't switch between them. Have consistent formatting. And I would recommend this. I'm actually doing the research for all of this and talking to people. I'm probably going to hire someone professional to look at my resume and my different social profiles. And I think that's probably a good investment in your career. So create a master resume, which you'll post on job boards and keep in your files. But when you're applying for a specific job, you're going to want to have to tailor them. If here was a tip I got: if someone finds you on a job board, a recruiter, and you have your master resume up there, go ahead and say, hey, can I send you an updated one? And then make sure that resume aligns a little better with the job or the company. Here's some other things that can help you. Make sure that your resume has words and phrases that are peppered with things that are in in the potential field. You might want to look at other people in the field, how they describe themselves, and then make those keywords into your resume where it's applicable so people can find you. A lot of people, I mean, most companies and firms these days use some sort of screening software or do keyword search. And so you want to make sure what you've done in the past somehow reflects some of these words that they're looking for. Resume organization, this kind of gives you a start, your contact information, your summary, skills, work experience, education, and certifications and interests. Contact information, you know that. Just make sure it's up to date. That's sometimes something you don't check. Just check the number, telephone number, the email. This is something that's highly recommended. A summary right at the beginning about who you are, telling your story about yourself in a very precise and concise manner. It's going to be probably difficult to do, so it's going to take you some time to do it. I would look at some examples and see how other people have done it in your field. You can have a skills section as well, just bullet pointed with specific legal skills that you have. Now, if you're just starting out and you don't have a lot of very specific legal skills, you can put down skills from other areas of your experiences, such as internships and volunteering. Your work experience is going to be in reverse chronological order, and then what's relevant to your profession. This is, for me, a challenge. I've been in this for a long time now, so I'm always wondering which one of these experiences do I need to scrap because it's not really applicable to what I'm doing anymore. If you're just starting out, you put down the things that are relevant, and don't forget internships and clinics. Lots of people worry about gaps in their work history. If it's just a few months, you can go with just having the start and end date in years, but then you'll have to be consistent throughout your resume. If there's more consistent gaps, I was advised that really you need to sort of briefly explain them. If you had a medical leave or you took time off to be with your family. Those things are perfectly acceptable. You just don't want the recruiter left to their own imagination, wondering what you were doing. Okay. As far as education is concerned, put down any degree honors or specialized certifications. Don't state your GPA. And believe it or not, I'm going to give you this advice, especially if it is low. Apparently people do that all the time, but that's just a joke. Just don't put down your GPA. Okay. If you graduated from a particular prestigious school, you may want to put this at the top, but in general, it's going to be more towards the bottom, this section. Okay. Certifications and the bar exam, don't include your bar score. Once we're barred and we're admitted, we're all been barred and admitted, there's no reason to put your score there. State where you're barred. Now, the only thing I'd say, if you're taking the UBE and you have a score, don't put the score down, but if you have a score that transfers to other states, then I would list that, because you never know if a firm is looking for an attorney that maybe can do class action in Alabama. So keep that in mind. If you have a security clearance, definitely state that. Those are very expensive for people to get for you, your employer. You have a section on interests, and just make sure, now the interest section is really just to make you seem like a real person. Volunteering. If you work, be careful about political affiliations. Just make sure, unless it's related to the job. And with religious organizations, what you specifically did that, like a food drive or a clothes drive. Okay, so this is the thank you letter, and this might also go to the training, but if you have an interview, always send a thank you email of some sort within 24 hours of your interview. It's best to just sort of thank the person for their time and meeting with you, and then mention one specific thing of interest to you from the interview to show that you were actually paying attention. Okay. With regard to social media, we're talking about just make sure that the various sections on your profile are actually completed. If it's not, then recruiters and hiring managers think you just kind of don't care. Make sure your profile matches your resume, and make sure you have a complete summary. I'm told that LinkedIn has a larger summary section, and if you can tell your story there, then it's definitely best to go ahead and do that and take full advantage. Oh, one more, that's going to take you a lot of time. So it's not something you can slap together. Yes.
So that actually leads to a question that I had noted that I wanted to ask, but it looks like one of our other attendees has that same question. It was asked about summaries. So the question was specifically, hold on, give me just 1 second. Are summaries relevant to legal resumes? And that's kind of the same question that I had asked and noted to want to ask you. I know LinkedIn has summaries. I know sometimes people can put them on their resumes. I've always kind of seen them before as fluff. So how important are they? And if they are important, you know, what type of things should you hit within it to make a good example?
From all the recruiters I've talked to, both in the legal field and non-legal field, apparently the summaries are extremely important. It gives the person the first impression of exactly who you are in a very concise, short manner. It's kind of like that, you know, conclusion at the beginning of the formal document. You're sort of giving them the upfront answer before they have to go through all of the details.
Okay.
And to that, I don't have an example of a summary, but perhaps we can make a note of that to perhaps get some examples of that.
And we can provide that in the resources that we have that we'll provide at the end of the webinar.
Okay. Just be careful after a recruiter gets your resume and looks over it, you might be a good fit. They do search all your public profiles, social profiles. I asked somebody what the weirdest thing that they said. Well, they said they went to one of the person's profiles and they had like all of these bodybuilding pictures up there and very small gentlemen in very small swimsuits, and not off-put, but she was a little bit shocked.
So relatedly, we have a question on that, and this may be for follow-up materials too, but Aurora asks, what are some reputable sources for resume and social media presence review? So many advertisements exist.
What was the first part, Ben? Sorry.
Reputable sources for resume and social media presence review.
I have put one company I know of in the resource in this as a resource slide that I used to get information from. My understanding is I don't have one off the top of my head, but there are quite a few. Perhaps we can look into that.
Got it.
Okay, make sure that you use active words, built, created, organized. Use real numbers. Numbers are very useful. By the way, write the numbers numerically. Don't write them out as a word. Apparently, it's kind of harder for people to search, recruiters to search that way. And be precise on your role on a project or team. And here's a little tidbit of information. LinkedIn has started using hashtags. I guess you might know this already, but apparently that's a great way to get your name out. And I have some resources here.
Great. Yeah, thanks. We have a couple other questions that just came in, so I think we have time to take them.
Yeah. One of the questions that came in is the age-old question about number of pages on a resume. So is 1 page or 2 pages of a resume more appropriate?
I did ask this question, and I think the answer is, are you writing that extra page to cram every single thing in there to the point that the person's going to get lost? I think initially in a career, it's probably a good idea to keep it briefer with 1 page. But you know, some people come from another career, and law is their second career. So you want to keep things on that resume that are relevant. If that takes you to 2 pages, it takes you to 2 pages. But you don't have to have everything on there. It should be related to what you're doing. And remember, you're tailoring that resume to the job that that is the job description, the job you're applying to. You're not just sending a generic resume. So maybe your master resume is longer, and then you can pare it down.
And then we had another one that came in, Ben.
Yeah, sure. We have a question. Do you address yourself as a lawyer or not if you have graduated law school and have not yet passed the bar?
Address yourself as a lawyer, and how would you?
Do you call yourself a lawyer when you haven't passed the bar yet, but you have graduated law school?
Well, you're not really legally allowed to represent anyone, right, until you have a license to practice in that state. So I'd be a little bit careful about that. I don't know the exact answer. I'm sure that different ethics boards have rules and regulations on that. I would definitely check with your state or where you're at. Do you guys happen to know, Ben? How do you know?
No, I don't know specifically, but I think it is jurisdiction by jurisdiction, ethics-wise.
Yeah, I'd just be very, very careful with that.
And if we can go ahead and squeeze this last one in before we wrap up, and then I'll close out. But the question was, what's the best way to request an informational interview if you're interested in a firm? And if there's no short answer, then we can post that information to the follow-up page. But if you do have a short answer for it, we can go ahead and answer it now.
I think that when I've seen that, most of the time there's sort of I'd like to contact or some link for that. And there's a small box you can request why you want to meet with them. I wouldn't be generic. I'd be a little bit more specific. First, do the research on the firm and see what they're doing, and then try to be specific as you can about why you want to meet. Not just I want to meet you, but I'm interested in these things that your firm's working on. I'd like to get more information.
Great. Well, I would like to say thank you to all of our attendees, and a special thank you to you, Professor Sabin, for taking the time and chatting with us for a little bit about these different areas that are important to young lawyers. We all experience situations where we kind of, like you said, we get to sit we start writing and we just kind of freeze and we're stuck there for a little bit. Like, what do we write? How do we write it? What do I get out what I want to say? So hopefully it is our hope, you know, Ben and myself, as well as the YLD litigation committee, that this webinar was able to at least help or touch on some of those issues. There will be a follow-up. The slides and the webinar will be available on the YLD website, as well as any conference attendees will get this emailed to them, as well as it'll go on a lot of the YLD Connect pages. If there's any follow-up or questions that anyone still has, please feel free to reach out, because we will be posting more resources to answer some of those questions or to discuss some of the things that we were not able to discuss today. But with that being said,
Aris, do you mind if I just add one thing with the difficult job market sort of that's out there? I just want to encourage all of you to not despair, because you're leaving law school. I think going to law school, the two greatest things that you have is your ability to digest large bodies and huge bodies of information. Your second best skill set is your ability to articulate that information to other people. That is useful in all different industries, whether you go for a firm or you go to traditional practice or you go in-house or you don't work in law at all. And that's the biggest lesson I've learned through my career. Those skills are going to be useful for you throughout your career in many different situations. Thank you for having me today.
Well, with that, we will leave it there, and we'll also give a special thank you to Tracy for her help on the back-end technical side.
Yeah, thanks a lot.
Thanks everyone.